There is a guy called Sunday Jackson, a farmer in Adamawa State. And he went to his farm just like any other person would do, not knowing what was going to befall him on this very day. Now, on getting to his farm, he saw some Fulani herdsmen who trespassed into his farm. And story had it that the headmen also discovered that one of their cows maybe had been missing, and they were looking for whoever did that. Now, in the process, the Fulani headman attacked Sunday Jackson with a dagger with the intention to actually kill him.
I don't want peace. I want problems always.
But Sunday Jackson overpowered him and snatched the dagger from him and stabbed the Fulani headman about 3 times.
Damn!
And the Fulani headman died. And this was the decision of the court.
I need a lawyer.
Welcome to another episode of Leducation, the legal podcast where we break down legal concepts, legal principles, legal ideas, or legal terms. We break it down in a way that you will understand without going to the law school. All right. We started our discussion last time on how to get away with murder. I've received a number of messages, questions, and all. Don't worry, we are going to break everything down to you in this series. Now, today we are looking at one of the defenses to the charge of murder. That is, when somebody is accused of murder, what are the defenses available? I mentioned a couple of them last time. Go and watch that video if you have not watched it, so that you can flow with whatever we are going to discuss today. Now, one of the defenses is self-defense, and that's what we are going to be discussing today.
That's absolutely brilliant.
I'm going to discuss with us the meaning and the nature of self-defense, the statutory provision that guides self-defense as a defense to criminal charges, and then what are the ingredients of self-defense, what must be available or what must be present before you can successfully raise the defense of self-defense. And then we are going to look at something called proportionality in this series. Let's start with the definition of self-defense. Now, the idea or the nature of self-defense is such that somebody who is accused of killing another person raises this defense that he was actually threatened, or he feels threatened, or he reasonably believes that he was going to die except he took the action that he took. Now, let me put it exactly the way that it is in the law. Now, let's look at section 286 of the criminal code says, when a person is unlawfully assaulted and has not provoked the assault, it is lawful for him to use such force to the assailant as is reasonably necessary to make effective defense against the assault, provided that the force used is not intended and is not such as is likely to cause death or grievous harm. Now, if the nature of the assault is such as to cause reasonable apprehension of the death or grievous harm, and the person using force by way of defense believes on reasonable ground that he cannot otherwise preserve the person defended from death or grievous harm, it is lawful for him to use any such force to the assailant as is necessary for defense, even though such force may cause the death or grievous harm. Now, what this simply means is that when you are being assaulted, you have the right under the law to defend yourself with such reasonable force against that assault, as long as that force that you use does not cause the death of the other person. However, in situations where you are under the apprehension that this person is coming to kill you or to cause grievous harm, you have reasonable grounds to believe that this person is coming with a machete to machete you, and this is going to cause grievous harm or death unto you. The law says you have the right to defend yourself with any such force in that situation, even though that force may cause the death of the other person. You are still not criminally liable under the law.
This is amazing.
So in this situation, you or anyone who defends you in that situation, for instance, that I am under the fear that I'm about to be attacked, or somebody is coming to attack me, to assault me in such a way that, if successful, may cause my death. But there is a friend of mine who is close by, and having seen that I'm being overpowered by this other person, uses certain force to against this other person to defend me. Both of us in this situation are not criminally liable for the offense of murder, not even for the offense of manslaughter. This is the nature and the meaning of self-defense under the law. proceed to look at the statutory provisions that guarantees this right under the law. Now, let's start with the Constitution. By Section 23 of the Constitution, every man has a right to life. It's a constitutional right that nobody should take the life of another. But there are certain situations that have been highlighted under the Constitution where this can be reasonably done without anybody being accused or being criminally liable.
Sounds too good to be true.
By sub 2 of that provision, that is Section 33 sub 2 of the Constitution, if you look at paragraph A, now it provides that a person shall not be regarded as having been deprived of his life in contravention of this section if he dies as a result of the use to such extent and in such circumstance as are permitted by the law of such force as is reasonably necessary, A, for the defense of any person from unlawful violence or for the defense of property. Now, this explains what I've explained before, that if you are under apprehension of death, a friend of yours is under apprehension of death, or even a property, that is what the Constitution says. And then look at the criminal code that we have just read. If you go and read from sections 286 to about 293, it deals with all of these issues. And under the penal code, if you look at section 59 to section 67 of the penal code, you have it stated there. Now let's look at the ingredients of this defense. From all the provisions of the law and even the decisions of the court in recent times, there are about 3 ingredients of the defense of self-defense for you to be able to successfully raise this defense. Number 1 is that there must be reasonable apprehension of death. There must be reasonable apprehension of death or grievous harm. That is, you cannot just say that, well, I feel this person is going to kill me. Now, it must be reasonable to the whole high that you are under threat of death, you are under attack, you are under the apprehension that you are going to die, or you are going to be grievously harmed. That's number 1. Number 2 is that it is necessary at that point. The only way you can escape that is to use force in this situation. And then number 3, now the force that you use must now be proportionate to the attack that is coming against you.
What are you saying? What are you saying? What is he saying?
There are factors that the court is going to look at to determine whether it is proportional or not. Now, if somebody is coming to attack you with, say, a stick, but you use a double-barreled gun against that person in that situation, will that be regarded as proportional?
What did you do to me? This baby man! What this life?
The court or the law requires that the force you are going to use against the other person in your own self-defense must be proportional to the attack that is coming against you. Not that you come to a battle of Cain with a double-barreled gun. Back to the case of Sunday Jackson against the state. Now, Sunday believed that he was under attack, he was under apprehension of death as envisaged by the law. And the only thing he could do at that point was to defend himself, which he did. Very unfortunately, the court thought otherwise. And the court said that the moment he overpowered his assailant, that the defense of self-defense can no longer avail him. That this is what the court is saying, that the man that came against him to kill him with a dagger, at that point, if he defended himself, it was fine. But Sunday was able to overpower him and collected the dagger from him. The court said at that moment that the fear of death had already evaporated.
Ouch him.
Well, that is what the court decided. And the court said that there were different options open to him. He could have run away, he could have done anything, but not to stab this other man 3 times.
Running, 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 run!
Well, no matter how unfortunate we feel this decision is, no matter how we disagree with this decision, as of the time of recording this video, this is the position of the law, because this is what the Supreme Court have just decided recently, I think earlier this March 2025. And as long as the Supreme Court has not overturned its own decision in another case, this remains the position of the law as it is. I hope you are being enlightened. I hope you have better understanding of this concept after watching this video. Do well to like this video, do well to drop a comment, do well to subscribe to this YouTube channel. Thank you for always joining us. We do really appreciate you. We will see you again in our next episode, where we bring again another exciting topic to you. Thank you.